With the permission of the honorable bench, we have teams Diamond for the appellants and team Morganite for the respondents. The team shall never disclose their identity in the course of their submissions. The team shall reserve 40 minutes within the team members themselves, and an additional 5 minutes for the rebuttals shall be exclusively reserved. Submission of the compendiums and the submission of any other documents shall be made only through the court officers. Any kind of direct communication between yourselves could amount to violation. If the instructions are clear to the participants, with the permission of the honorable judges, the proceedings shall begin.
Warm greetings of the day, my lordship. This is Counsel 1, appearing on behalf of the appellants in the matter of Private Hospital Management Association versus State of Dakshin Pradesh, my lordship. The Counsel 1 would be addressing issue number 1 and 2. Counsel 2 would be addressing issue number 3 and 4, my lordship. With due respect, the Council recognizes the gracious presence of leadership as part of the bench, but for the sake of the arguments and convenience of the bench, the Council humbly seeks permission to address the bench collectively as lordships. Much obliged, my lordship. The Council seeks permission to proceed with the statement of facts, my lordship. My lordship, the Republic of Astoria is one of the most populous nation with around 1.3 billion population, and it is governed by the Constitution of Astoria, my lordship. The Republic of Astoria is renowned for its medical tourism, which has attracted more number of foreign medical tourists because of its affordability to the healthcare. Majority, that is 70% of the healthcare that to the critical and specialized treatments are delivered by the private sector hospitals, my lordship. Astoria is also renowned for its global healthcare destination, my lordship. But the COVID-19 pandemic exposed a dark reality where people with the economic and the financial means were able to get access to the private hospitals, and people especially from the economically weaker sections struggled to have access even to the basic facilities from the private hospitals, my lordship. A parliamentary standing committee report also states that there is an inequality in access.
You better use the word BPL instead of EWS. We are more on people of below poverty line. So don't use the word economically weaker section.
Beg your pardon, my lordship.
I repeat, don't use the word economically weaker section. Use the terms below poverty line.
Indeed.
Otherwise, we are getting deviated from the proposition.
Indeed.
Okay?
Indeed. The BPL patients, that is people from below poverty line, struggled it difficult to have even the basic facilities from the private hospitals. The Parliamentary Standing Committee report on health also highlighted that the access to health is unequally distributed in Astoria. There is also a report stating that public hospitals remain overcrowded and they are not well maintained and they lack funds. The data shows that in metropolitan cities, patients often get frustrated due to the long waiting queues, my lordship. At the same time, on the other side, private hospitals are struggling to bear the high cost of advanced technology, my lordship, which they have invested. In parallel, the Astoria faces a chronic shortage of organ donation. And there were debates and discussions stating that the government of Astoria has to regulate the private hospitals, my lordship. The parliamentary debates also reflected a growing concern regarding the commercialization of life-saving treatment, my lordship. Taking this issue, the National Health Policy 2024 was enacted. In that National Health Policy 2024, certain percentage of the beds needs to be reserved for the economically weaker section patients, and the emergency treatment obligations was mentioned, my lordship. The state of Dakshin Pradesh, which is one of the top performers in the healthcare index, implemented Dakshin Pradesh Right to Healthcare Act, my lordship.
Council, none of your compromise encourages you to use EWS. That's what Brother Judge rightly mentioned. Use only below poverty line.
Beg your pardon.
Right? Don't make confused.
Beg your pardon, my lordship. The below poverty, in that, there are the section 3, section 4, section 5, section 6 and section 7 has been framed, my lordship. In that, all licensed private hospitals with more than 100 beds shall reserve 15% of their total capacity of beds for patients from below poverty line for non-communicable deadly diseases and to provide emergency treatments without receiving any upfront deposit. Section 4 deals with the medical professionals will be personally held liable in case of gross negligence. And Section 5 is about the obligations which is imposed on the hospital management regarding the retrieval of organs and the deposit of the retrieved organs in the depository banks, government or government authorized banks. Taking this into consideration, the Private Hospital Management Association, they filed a writ before the Honorable High Court of Dakshin Pradesh stating that their fundamental rights are violated. But the writ was dismissed by the Honorable High Court of Dakshin Pradesh. On dismissal of the writ, the Private Hospital Management Association filed an appeal before the Honorable Supreme Court of Astoria, my lordship. And the Honorable Supreme Court of Astoria has admitted the appellant's petitions, my lordship. If the bench is convinced with the statement of facts, the council seeks permission to proceed with the arguments, my lordship. Indeed, my lordship. My lordship, issue 1 pertains to whether the compulsory reservation of 15% beds for the below poverty line patients and the emergency treatment obligations imposed on private hospital violate the Constitution of Astoria. The appellants most humbly submits that the compulsory reservation of 15% beds for below poverty line patients and the emergency treatment obligations violates the Constitution of Astoria, my lordship. My lordship, Article 19, 1 subclause G mentions about the right to profession, my lordship. Here, Article 14 mentions about right to equality, my lordship. Drawing lordship attention to para 17 of the proposition. Para 17 clearly mentions that it is a selective imposition. Para 17 of the proposition, my lordship. In it, Section 3 explains about the mandatory obligations imposed on hospitals, my lordship. Here, the appellant says that this mandatory obligation imposed on hospitals, that is 15%, is arbitrary and unreasonable, and it is a selective imposition that is clearly mentioned under Section 3, subclause A. That is, all private hospitals shall provide immediate life-saving treatment to below poverty line patients in case of emergency without insisting on any upfront payment. The appellants accept that providing emergency treatment should not be denied. But this clause is vague. It mentions that emergency treatment should be provided without receiving upfront payment, which the appellants agree to it. But this clause is vague regarding the in case of non-payment. There is no provision which the government of Astoria, the state of Dakshin Pradesh, has never mentioned any provision in cases of non-payment, my lordship. And regarding...
Just see that subclause A,
my lordship.
explanation 1.
Indeed, my lordship.
Yeah. Treatment for such patients.
My lordship, that is subclause A, my lordship.
And
This is subclause B.
explanation 1.
My lordship. It is written that for non-communicable deadly disease, it is completely
No,
free.
section 3,
Indeed, my lordship.
subsection A,
Indeed.
first explanation.
All licensed private hospitals with more than 100
No.
beds.
He said explanation number 1. Above that. See, just see 4th line from the top on subsection A.
Equivalent fiscal or tax incentive to the hospitals.
Yeah,
my lordship.
what do you mean with it?
My lordship, that is for non-communicable deadly disease, which is under section 3A, my lordship. The council is mentioning about section 3 with subclause B, my lordship.
No, I just ask you, treatment for such patients shall be provided totally free of cost. In turn, the state government shall extend equivalent fiscal or tax incentive to the hospital. Do you think that the hospitals are not protected?
My lordship, it is only a equivalent fiscal tax incentive, my lordship. It is not a amount of compensation. It is only 5%, 3%, that all. The government hasn't mentioned the exact percent. And the National Health Policy 2025, it's 0% GST, my lordship. Here it is clearly mentioned that equivalent fiscal tax, not a compensation amount. The contention is regarding the compensation amount, my lordship.
Okay, wait a second. And you mentioned about only 0% GST. What about the other taxes that any building or any person pays? Including, I guess doctors pay income tax, service, professional services, and then there is an urban taxation, urban local bodies taxation. So
Indeed,
there is so much of taxation. If you want concession, then they'll give you all those concessions that are required. And there is no vagueness I find in the provision.
My lordship, the vagueness is regarding 15% reservation, my lordship, or the alterum partem. The appellants, the Private Hospital Management Association is willing to give the reservation, my lordship, but this 15% is arbitrary and unreasonable because our side is not being heard. And it clearly says that all licensed private hospitals having more than 100 beds.
Wait a second. Where does RD Altrum Partum applies?
Because while forming the 15% reservation for the below poverty line patients, they have fixed it as 15%, and there is no substantiated proof or report, the burden of proof to say that 15% is needed.
It doesn't applicable. It is not applicable to legislature.
My
RD Altrum Partum is a process that somebody is follow when there is a dispute resolution.
But on behalf of the Private Hospital Management Association, my lordship,
Counsel, could you read paragraph 11 of the compromise to substantiate how the Article 14 is not followed?
14, my lordship.
Paragraph 11.
It's a fact-finding studies and media reports, my lordship. Media reports, there will be n number of media reports, my lordship. If that is the base, there is a media report, there is a fact-finding study that says that public hospitals remain overcrowded, not well maintained, which is mentioned under para 8 of the proposition. And the data shows that in metropolitan cities, patients often get frustrated due to long waiting for critical surgeries, my lordship.
No, you continue with the line. Where patients from weaker sections were denied admissions, asked to make heavy upfront deposits. Is it not a duty of the government to regulate you?
My lordship, there is no contention with the regulation, my lordship. The clause, the provision is vague because in case of non-payment, there is no assurance from
No, as a sovereign state has the freedom to fix what is the quota in which any hospital license may be given or granted.
Indeed, my lordship, it was clearly mentioned under the Clinical Establishment Act, my lordship.
Very
There
good.
is no denial.
Then where is a choice for the council to make a submission by saying 15% whatever is fixed, it is irrational?
Because, my lordship, it is clearly stated that all licensed private hospitals having more than 100 beds, my lordship. There are hospitals with 1,000 beds. For them, 15% is not an issue. But there are hospitals with only 105 beds. There are hospitals only with 500 beds. In this case, there are mid-sized hospitals, there are large hospitals. It becomes a huge financial burden, and in turn, it is also a professional burden, my lordship. The concept.
Okay, let's stop this kind of argument. You enter into the constitutional dimensions of it.
My lordship.
Where it stands violated, you just proceed on question.
My lordship, it is violation of Article 19(1) subclause G, my lordship. Right to practice prevention, my lordship. It is violation.
Do you think that is it against a reasonable restriction?
My lordship, it is unreasonable. The 15%,
And what point you say it's unreasonable?
because 15% is a huge burden, it is disproportionate.
15% is a huge burden.
Indeed, my
Anything else than other than
my
except
lo-
figure?
My lordship, it is the figure is mentioned. The Private Hospital Management Association is willing to provide the reservation.
How do you argue that is it against reasonable restriction?
Uh,
Do you agree reasonable restriction is available in the constitution?
Indeed, my lordship, reasonable restrictions is there.
How it is against reasonable restriction? In what point you are differ?
Because it imposes a huge financial burden, and it also becomes a
Against
profession
whom?
against the private hospitals, my lordship.
You see explanation 1, what it says. Treatment for such patients shall be provided totally free of cost. In turn, the state government shall extend equivalent
My
to be
lordship,
compensated.
my lordship, it is only a tax incentive, my lordship. It is not a compensation amount. Point number 1 of contention. Point number 2 of contention is, my lordship, within
Equivalent-
how many days the government will be providing an equivalent fiscal or tax incentives.
Now, your point is you are ready to provide free treatment. I mean, provide for treatment immediately without any restriction. Only the non-payment is a matter.
Not only non-payment, my lordship, the
You
15%,
highlighted that if any amount is paid subsequently after treatment, then what will be the case?
it will be taken into consideration. Being in a medical profession, the appellants accept that medical treatment should not be neglected, should not
You
be
are ready
denied.
to provide a treatment
Indeed, my
immediately
lordship.
without any restriction, hesitation.
Indeed, my lordship, but the clause is vague regarding the non-payment. That is the contention. Regarding the first part, the contention here is fiscal incentive will be provided. But what is the equivalent percentage? The equivalent percentage has not been mentioned.
No, I just want to know how do you say that you are aggrieved under Article 19(1)(g)?
Because it imposes a burden on the profession, my lordship. Drawing lordship.
So is it attract the profession of the individual doctors or it is a hospital?
Both doctors and hospitals, my lordship.
Would the hospitals are eligible to claim 19(1)(g)?
My lordship, it affects the individual doctors also, my lordship. Doctors are working for the hospital.
Who is an applicant here? Is it a doctor? Is it a private hospital organization?
The private-
Is available to the natural persons or artificial persons like private hospital organizations?
My lordship, it is applicable to the natural persons. Here, the group of private hospitals, the medical persons are the natural persons, my lordship. They form.
Then who is an applicant? Is there any named after X or Y? Who is an applicant here?
Here, the
Appellant. Who is an
the
appellant
appellant
here?
is not explicitly mentioned because it is complete. It is the legislation is covering all the private hospital, my lordship.
All the
If an-
private hospitals,
Indeed,
right?
my lordship.
Private hospital representing on what?
Private hospitals is representing the private hospital management associations, my lordship.
Management. Are they natural persons or artificial persons?
My lordship, associations are an artificial person,
Would
but
they
they
eligible to claim 19(1)(g)?
but indirectly they are eligible, my lordship, because
Where? Any substantial portion to strengthen, indirectly they are eligible to enjoy 19(1)(g).
para 9 of the proposition says that
What does it say? Read.
private hospital management express that they are struggling to be a high cost of advanced technology,
Yes.
infrastructure maintenance.
Is any line says they have a
Medic-
fundamental freedom of practice, profession, occupation, and so on? Any line from Compromise could you substantiate?
My
Or
lord-
any judgment which is given by honorable bench?
My lordship, the association represents the interest of doctors working under the private hospitals, my lordship. Individually, all the doctors can't come and file a petition here. Instead of that, it is represented by the association. Their association is also representing.
Council, clarification is very simple. Would these private organization come under the definition of citizens? What 19 say?
My lordship, association is an artificial person, but the association is speaking on behalf of the medical professionals who are the individuals, my
Okay,
lordship.
besides
And
19, what all constitutional right is violated?
my lordship, Article 14, my lordship.
Okay, read Article 14.
And-
Right to equality, my lordship.
And what what was expected, you have to give the explanation to us regarding how artificial persons are treated under Article 19(1)(g), and give examples or cases from this court.
Okay, Manj. In Social Jurist versus Government of NCT Delhi and Moolchand Karaiti Ram Hospital versus Government of NCT Delhi, in these cases, the government accepted that it upheld the reservation for the economically weaker sections and PPL patients, my lordship. But the ratio decidenty before.
Council, you are submitting how the individual's interests are taken by the court. Now we are not asking any individual interests are taken. It is a question of how you will demarcate between interests of natural person versus artificial person.
My lordship, the interest of natural person is involved, but the interest of
My brother judge specifically asked, could you cite any judgment by saying even artificial persons are eligible to enjoy freedom under 19?
the council will look into it.
You have to answer
Okay.
two doubts asked my.
Leave it to
But
the
just put
researcher and continue with 14.
Number one, under which category you claim to be a person who is coming under the classification? In which way you are better placed than the other class of people? Number 2, whether Article 19(1)(g) and Article 14 applies to such a what is called artificial or non-juristic person like a citizen. These two questions are very much relevant for the purpose of adjudication of the dispute. Am I right, sir?
Yes.
My lordship, here the interest of the persons, individual persons, is represented through an association, my lordship. That is the option left to the appellants, my lordship.
So you skip 19. Okay, because you said your researcher will do. You jump with 14.
Right to equality, my lordship. Here it is selectively against the private hospitals having more than 100 beds, which means that it is a selective imposition, my lordship. This selective imposition is violating the equality, my lordship. And there is a stance in this social juris versus government of NCT, Mulchand Karaitiram Hospital, government of NCT. The stance, the ratio dissidentity behind upholding the reservation is, to all these hospitals, government has given a land on a concessional basis, my lordship. But here, all the private hospitals haven't got any land on concessional basis, not on subsidized rates, my lordship. Can we prove you the concept?
What is that idea? That you said you don't have any GST. You agree that there is no GST. Don't say that government is not giving any concessions.
My lordship, land, I'm talking about the land.
Land is something different, and this case is entirely different. So let's leave this and talk about your rights under Article 19 or 14 of some other.
Indeed, my lordship. My lordship, here the contention is there was not it categorizes only on one criteria, that is the 100 beds, but there is no reason why the bed is taken instead of the amount of revenue or something. But the only criteria which they have taken is a 100-bed criteria.
Council, we are in a democratic country. Where are the choices are as to make a suggestion? These should be considered. These should be considered. Now the law is in front of you. How it is going to violate your equality under Article 14? Because 19 you fail. Jump with 14. You read 14. You list out. These are the grounds in which our freedom to carry profession is violated.
It is violated because it is selectively against certain group of hospitals.
Okay.
Point
Where
number
it
one.
say the selective proposition need not be followed by the sovereign as and when they are intended to make laws. Give one substantial provision.
My lordship, this selective provision is a burden on the part of the hospital that is,
Council, you are thinking of your interests. We are speaking of sovereign authority to make. It may be a burden. Is it not a prerogative on the part of the sovereign to decide which should be protected, which shouldn't be protected?
my
You
lordship,
jump with 14, speak substantially.
and there is no scheme of uniform compensation scheme, my lordship. For if a hospital is giving reservation, how uniformly they will be distributing the compensation amount. This provision lacks the uniform compensation schemes, my lordship, and it also
Council, I just want to draw your attention to a repeated case of this Honorable Court in Union of India. It is Society for the Unaided Private Colleges of Rajasthan, as Union of India, where in pari materia, when reservation was given for poor students, 15% for the students of a private school, we have already found that it is applicable. There is no violation of Article 14. There is no violation of Article 19(1)(g), and it only amounts to what is called a vertical reservation. Would you want to say something against what is already decided by the constitutional bench of this Honorable Court?
My lordship, it is regarding the educational institution. Here it is regarding the hospitals, my lordship, that is selectively against
Said
the...
very clearly in pari materia.
It is in pari materia, my lordship, but the contention here, the real burden...
Yes, Council, please jump to your issue number 2.
Indeed, my lordship.
Okay, because already I have exhausted more time.
My lordship, issue number 2 pertains to whether the provisions requiring hospital management to facilitate organ donation in case of brain death with family consent and without the explicit prior consent of the deceased person amounts to violation of the right to privacy, bodily autonomy and dignity under the Constitution, my lordship. The appellant humbly submits that the provision requiring hospital management to facilitate organ donation in case of brain death without the explicit consent of the deceased person and only with the consent of the family violates the Constitution of Astoria, my lordship, and it violates the right to privacy, bodily autonomy and dignity under the Constitution, my
For
lordship.
example, there are unclaimed bodies or persons whose identity is not known to the people. What do you want the state to do?
My lordship, in that, in clarification, it is clearly given that when it comes to unclaimed bodies, para 6 of the clarification clearly says that does not contain any provision expressly dealing with organ retrieval from unclaimed bodies. So the legislation clearly states that there is nothing related to unclaimed bodies, my lordship. Clarification sheet, para 6, my lordship.
Yes, Counsel. So all the rights you have mentioned arising out of which provisions of the Constitution?
Article 21, my lordship,
what does
right
it
to
say?
life, my lordship.
Okay, you read Article 21. Especially focus last line.
Indeed, my lordship.
No person shall be deprived of his life or personal liberty except according
Authority.
to procedure
Procedure established
by law. What is the law you have?
My lordship, in this case, Justice K.S. Puttaswamy versus Union of India. it has-
Counsel, we are asking a law. You are asking a judgment. Whether judgment is it a law?
My lordship, judgment is to substantiate with the evidence, my
Very
lordship.
good. That's what. You speak law, then you substantiate with the judgment.
My lordship, it should be according to the procedure established by law, my
Very
lordship.
good. Where is the law? Then you jump with the procedure.
Here, the deceased person, it is a brain death, my lordship. The brain death person, at what time he will be declared as a death person? What is the procedure that the government, the state of Dakshin Pradesh will be following? It lacks the, it is vague. There is no mention about the procedure. It is only a brain death person, and the definition for the brain death person has also not been given. They have explicitly said that the brain dead person, his family will be consulted. If the family give the consent, his organs will be retrieved. But
Class B and C, they clearly speak of an internal committee, and the committee will file one more registry. So it is not that they have no procedure at all to identify such things.
my lordship, it is retrieval of organ. For that, the committee will be formed, my lordship.
They will also instantly decide all these questions. It is not that the state is without any mechanism.
My lordship, it is only with the consent of the family. In a what it is clearly given that consent of the
You
family.
want to say it is dealing with the posthumous dignity?
Indeed, my lordship.
Make it very clear.
Will make it, my lordship. My lordship, Ashray Adhikar Abhiyan versus Union of India, right to dignity extends to the deceased person also, my lordship. Here, the deceased person's organ without his explicit consent is taken, and it is only mentioned as the family. Family includes the near relatives, the far relatives, and who is the family in this definition? It has not been mentioned. What if,
Counsel, you have been arguing on definitions.
my lordship?
For a moment, you please forget about it, because we all have definitions, we have working definitions, we will evolve it over a period of time, or else this court will do it, it has done. So don't worry about the definitions or even vagueness of the provisions. Look into the substantial issues, or substantially see how this provision violates the Constitution.
My lordship,
Whenever an act is enacted, as my brother just said, we have got mechanism to frame rules. And this court has got every power to frame rules. We have got Article 142. Just go on the substantive provision. Don't cite on this kind of exceptions.
Indian, my lordship. My lordship, in Samira Collier versus Dr. Prabha Machanda, the Supreme Court required that the consent should be specific to the procedure, fully informed, voluntary, not presumed or implied. Here it is a presumed or implied, my lordship. Here it is only the deceased person before during his lifetime he haven't given the consent. And the important question rises is, when voluntary measures are there for organ donation, which every layman knows, what is the need to adopt a coercive means when voluntary opt-in systems are already available, my lordship?
You know the plight of peasants who are waiting in the long queues for organs to be donated. Do you want them to go in a hurry? There must be something by the state, no? They have also got a right of dignity on Article 21. Right of life is equivalent to right of death.
My lordship, the same way, the deceased person also have the right, my lordship. It is already clearly established in Ashray Adhikar Abhiyan versus Union of India.
Between the two, which is superior?
My lordship, life of saving the life of the other person is superior, my lordship. There is no contention regarding this. But here, again, the consent is very vague. The family consent is very vague. And for what consent? Family includes 4 persons. What if the 2 persons are giving the consent and the other 2 persons are not giving the consent? In that case, how will the state of Dakshin Pradesh will ask the private hospital?
Don't worry, this court will take care of all these things.
Indeed, my lordship.
I think your time is over.
You are in a constitutional court. Establish the substantial basis of our arguments.
Indeed, ma'am.
As our brother judges repeatedly mentioned, you are try to find a flaw in the procedural. Procedural could be rectified. You make a substance. You mention your 21 is violated. Use substance. Are there any other law made you to say the procedures are mentioned for the organ?
You give the matter to another person. The time is over.
Indeed, ma'am.
Substance. Please, please.
Obliged, your lordship. Continuing from where my Lone Council concluded, I shall be addressing the constitutional.
Use your mic because they are live streaming. Use your mic. Use your mic. They are live streaming.
Okay, my lordship. Much obliged, my lordship. Obliged, your lordship. Continuing from where my Lone Council concluded, I shall be addressing the constitutional invalidity and the unreasonableness of the impounded provision under the challenge. May it please the Honorable Supreme Court of Astoria, I'm counseling, appearing on behalf of the appellant, challenging the validity. My lords, this case concerning a profound overreach by the state of Dakshina Pradesh, which under the guise of welfare legislation has imposed a trade-off coercive and unconstitutional obligation upon private hospital. These are the mandatory formation of internal breakthrough certification committees and instantaneous report mandate the state government to the SOTTR, that is the State Organ Tissue Transplant Registry. Most egregiously, the exclusive transfer of retrieved organs only to government or government authorized bank.
The word instantly in the particular clause. Do you mean to say that the entire provision is invalid or it is unconstitutional? Are you not supposed to use the doctrine of reading down?
Yes, my lordship. Indeed, my lordship, they can use it. What we were stating is the instantaneous reporting. There is a lot of procedure lapse when it comes to this particular provision. As my
Counsel. Use a word what we are submitting or presenting. Don't use what we are stating.
Much obliged, my lordship. What we were stating was there is a procedure.
What you are presenting.
Submitting or presenting.
Much obliged, your
You are not
lordship.
supposed to state. You are supposed to present or submit.
I will submit, my lordship. Instantaneous report. It clarifies that there is a necessity for us to create the report when it comes to the emergency. In terms of emergency situation, we need to be in a situation where the brain death committees have to be enumerate the instantaneous report for this particular internal brain death certification. It literally violates the. It literally infringe upon the professional judgment. It micromanage the professionalism. Under Section 5 mandates the formation of internal committee, instant reporting. It's rigid. A clinical judgment to delay a retrieval by organ to optimize the donor's condition become a legal violation, my lordship. The doctrine of solus pauli suprema lacks, invoked by the state. We respect that, but the welfare of the people is not served by the stripling medical professional of all the autonomy, turning them into the cogs into the state mission. This court has constantly held the professional judgment in a critical care cannot yield to bureaucratic formalities, my lordship. As I substantiated the answer, I move forward to the upcoming argument. Much obliged, my lordship. First, the Section 5 is a sledgehammer that shatters the delicate glass of consciousness protected by Article 25. To every person, the freedom of consciousness and the right to freely profess, practice, and propagate religion. This protection extends to not just individual, but also institution run by the religious group. Section 5D of the Act writes roughshod through over it. May I invite your lordship attention to the nature of obligation. The law mandates that every private hospital must facilitate organ retrieval upon brain death certification and deliver those organs exclusively to government banks. The Moot provision clarifies, and I quoted, that especially in 13th point, the DPRH Act 2025 does not provide for any religious exemption.
Do you think religion will come on the way?
Yes, my lordship, indeed. It comes.
Make it clear then.
Yes, my lordship. My lordship, for countless culture, the religious decision upon surrounding the body after death are not administrative formalities. They are sacrosanct, tied to deeply held belief about bodily sanctity, burial ritual, and afterlife. Section 5D for the Act compels religious affiliated private hospital to participate in organ retrieval process that directly violates their core religious tenets regarding the sanctity of the human body after death. This is compulsory mandate infringe upon both the internal of belief, forum intrum, and its outward manifestation, forum extrem, as guaranteed by the Article 25 of the Constitution for the
Wait, doctor.
religious.
Which religion prohibits organ donation?
My lordship, every religion, provide donation over the.
So if that be the case, only agnostic and atheists can give bodies. I don't think it is so. Am I, sir?
Much
Yeah,
obliged,
proceed.
much obliged, Your lordship.
I guess no religion is prohibited.
Much obliged, Your lordship. But our stand, appellant stand would be take that for
No,
religious.
substantiate, it does not stand. Like what I wish to say, I mean, here is you give points to us, you give religious text, you give cases.
My lordship, drawing your attention to the Orthodox, Muslim, Hindu, and Jains, whose doctrine prohibited mutilation or consciousness made inescapable by the threat of license, forced participation amount to the violation of consciousness made inescapable by the death of license cancelling, my lordship.
Which verse of Quran? Which verse of Jain text?
The council were unaware of as of now.
It's a
We will
word
look
of
forward
mouth.
into it.
It's a word of mouth, or in our plan it's hearsay.
My lordship, it has been.
Okay. It is ignorance of fact. You proceed.
Could you read paragraph 10 of compromise and substantiate whatever words we use from your mouth without any substantial literature?
Much obliged, Your lordship. In parallel, Australia faces a chronic shortage of organ donation. Less than one donor per million population contribute voluntary to the national organ pool, which is accepted by the appellant council. What we were taking as a defense for such, compared to the Spain country, it is the most prominent government authorized by the national pool of contributing.
Sorry for the interruption. According to you, it must be voluntary, not mandatory.
Yes, my lordship.
Make it very clear and simple. Say that it should not be imposed on anybody.
Yes,
It
my
violates
lordship.
Article so and so.
Yes, my lordship, it purely based on free consent. If I would say, the donors were not forced to donate their organ. We are not stating that. What we are humbly submitting that there is as the judges prescribed that.
Then please we revisit council statement how it is religious freedom encourages your dignity when you give a voluntary consent with respect to organ donation.
My lordship, bodily autonomy. The act state that the family consent were required by the respected medical hospital. But what we were stating is bodily autonomy. Every individual has their own right. They can decide upon their own. As the judges has already prescribed before, in every member of the family, the one person will be a religious person.
Substantiate the same with the last line of the same paragraph of the compromise. Meanwhile, paragraph 10, last line.
Yes, my lordship. Meanwhile, economically sound and wealthy people identify their donor with the help of the private hospital and
With the help of you.
My lordship, indeed, my lordship. The appellant council response would be, they are making it as such, but the stand would be cold isemic time. Even for every donation, there is a stipulated time period. They are making the priority list. We stand by it, but the organs cannot stand.
Council, make your submission very clear. Whether the procedures, whatever mentioned in the act is constitutionally wires or it is violate your fundamental freedom of religion.
The appellant council humbly submits that it violates our religious conciseness, my lordship.
So therefore procedures, let it go.
No, not like that, my lordship. The religious are body sanctity. We are humbly stating that they are sacrosanct, deeply to the held belief of.
So in this matter, there can be no secular procedure. Am I right? That's what you want to submit.
No, my lord. The Honorable Court of Astoria had lot of secularism. Even the UCC had been applied to the Bihar. Yeah, we respect that. But what we were stating is humbly saying is.
So don't get confused. UCC is for the organ transplantation or for a personal matter. Okay.
Much obliged, your lordship. The imposition of such coercion by the law undermining the constitutional principle of voluntary consent embodied in the.
Get the word coercion council.
My lordship.
You are doing something new. Where you get a good position? No, we are sitting with a compromise. Something we do not see.
Because of the word mandatory, you infer that mandatory will amount to coercion, right?
Yes, my lordship. Section 7 mandatorily stating that the cancellation of private hospital license amount to violation of it's considered to be a coercion, my lordship.
Violation of incomplete violation of. Already your sister council made you the answer. 19
Yes, my lordship.
expecting from you.
Yes, my lordship. If
I think she is more on Article 25 than Article 91G. I would be happy if you insist more on mandatory handing over of the organs to the government, not a private
I
body.
need a novel clarification from you, learned counsel, from your written memorial, page number 24, first 2 lines.
Yes, my lordship.
Ah,
My lordship. Which part, my lordship? Beg your pardon, my lordship.
page number 24 of your written memorial.
Yes, my lordship.
First 2 lines under page
Section.
3.3.
Much obliged, my lordship. Section 5 of the DPRH Act.
No. It starts with medical professionals.
Medical professional, yes, my lordship. The medical professional and hospital administration have a domain of professional autonomy, decision about the allocation of resources, staffing, priorities of care, internal governance, and institution discretion.
Okay, where you got this? Which law made you to say you can behave with the discretion?
My lordship, it micromanages our decision, my lordship. For example,
Where you are given a power.
Section 5 mandates that especially respectfully submit DPRH Act. Section 5 mandates the formation of internal committee, instant reporting and rigid timelines. It strips hospital of their discretion to manage the ICU resources, staff allocation and emergency priorities, clinical judgments to delay retrieval organ by HAR to optimize the donor's condition become a legal violation.
Whatever you do, no institutional interferences. That's what you are making.
Professional decision, my lordship. They were micromanaging the professional decisions, my lordship.
Continue.
Much
Okay,
obliged, my
come to the
lordship.
fourth issue.
Much obliged, my lordship.
Continue the fourth.
Much obliged, your lordship. Second, the crucial and that is constitutional doctrine of proportionality and pluralism requires accommodation. While the state obligation objective to increase organ availability is constitutionally valid, Section 5D is neither a necessary nor a proportionate means to that end under the strict scrutiny initiated in Justice K.S. Puttasamy versus Union of India. The blanket imposition disregard less restrictive alternatives such as referral to secular retrieval centers or coordination through recognized agency like NOTTO, which respect really
Open Puttasamy.
a conspirative agent of the state. While the state had broad regulatory power, it can't use coercive threat to transform private actors into unwilling arms of the state. Section 5D transforms private hospital and their staff into an unwilling, uncompensated agent of the state.
Issue number 4.
Much obliged, your lordship. Much obliged, your lordship. whether the imposition of civil and disciplinary liability on the doctor and the cancellation of license of the private hospital for denial of emergency treatment is reasonable under the Constitution. Need for the initiating the issue.
Issue number 4 says civil and criminal liability. You are bringing institutional liability.
My Lordship, it has been clearly mentioned in the issue that whether the imposition of the civil and disciplinary liability on the doctor.
Compromise paragraph, issue number 4 says whether civil and criminal liability imposed on a doctor or cancelling the license.
Much obliged, Your Lordship.
What is the disciplinary liability?
Moot, in the moot proportion,
Which paragraphs are it?
moot proportion issue for the consideration. The fourth one has been mentioned that
I'm reading.
whether civil and disciplinary liability imposed on the doctor and cancelling the license.
Counsel, whether civil and criminal liability imposed on doctors and cancelling the license, where you got disciplinary liability.
My Lordship, in the issue proportion, there has been no mention about the criminal liability.
reading it right?
It has been clearly mentioned civil and disciplinary liability imposed.
So in case of criminal liability, it is anybody's guess that it must be the individual doctor who has done it. Please don't go for criminal liability for institution. Divide the part into two and proceed further.
Much obliged, my Lordship.
Okay, continue. Let us assume it's a good, correct one. Right, continue.
Much obliged, Your Lordship. May it please Your Lordship, the Dakshin Pradesh Act 2025 imposes a severe obligation and liabilities on the private hospital and doctors with disproportionately curtailing their fundamental freedoms guaranteed under Article 40, 19, 1G and 21 of the Constitution. The Act, though properly enacted in the interest of the public, exceeds the limit of the reasonable restriction regulation by the infringement upon the freedom of profession.
In case of violation, what do you want the state to do? Simply keeping quiet? Or letting the scot free, all this person to go? There must be some punishment, na?
It's not
It may be either civil or criminal. What do you want the state to do then?
much obliged, my Lordship. But it has to limit in our perspective, license cancelling is a graveyard for the corporate death sentence, my Lordship. From our point of view, a mirror instant of dispute, non-compliance cannot justify the license cancelling of civil or disputed liability. Much obliged, my Lord. Disciplinary liability, as these penalties are wholly disproportionate. Your Lordship, as held in the Maneka Gandhi versus Union of India, 1978, 1 SSC 248, all state action must meet the test of fairness, reasonableness, and proportionality under Article 14. Similarly, the European Court of Human Rights in Hasty versus United Kingdom, 1976, 1 EHRR. Much obliged, Your Lordship.
You are standing in front of which court?
Astoria, my Lordship. Astoria. My Lordship. Honorable Supreme Court of Astoria.
Astoria, right.
My Lord.
So you have cited a judgment from 19 Maneka Gandhi versus Union of India when?
Hungary.
You open your that memorial and say, what's the footnote when it was? Okay, so Maneka Gandhi, is she a natural person or is it nothing but an organization or private hospital?
My Lordship, individual person.
Individual. So now you are standing for individual or for an association council?
Association, my Lord.
Okay, whether are you eligible to claim 191G?
My Lordship.
Okay, one. Second, which made you to cite a judgment from European Court of Human Rights? What is the human right issues involved, counsel? Whose human right? Is it of doctors' human rights, patients' human rights, or private hospital association human rights?
My Lordship, professionalism and professionalism, my Lordship, it comes in the knees of that. We are stating, we are not directing the court. We are humbly requesting the court to see the Hayside versus Union of United Kingdom to they have mentioned the penalties must maintain a rational nexus to the gravity of the wrongdoing, not cancelling. It clearly shows that there is no extreme liability placed on the professionals.
What is the validity of that particular judgment to the Supreme Court?
My Lordship, Maneka Gandhi shows the test of fairness, my Lordship.
Counsel Maneka Gandhi already we finished.
Much obliged.
191G is applicable only to the natural person.
Yes, ma'am.
You are not standing as a counsel for any individual, right?
Much obliged. Yes, my Lordship.
So now you clear to support your sister counsel whether 19(1)(g) is for a natural person or for artificial person?
My Lordship, if I want to substantiate my point, I would be, Your Lordship, the maxim, let's not call it
Counsel, I don't want. I want a direct answer.
My Lordship,
19(1)(g) is for a natural person or the private hospital association. Then when you say that we'll take an inference from Maneka Gandhi 1978.
much obliged,
Right.
Your Lordship, considering your contention,
It's not a contention, clarification. We are no more counsel by the respondent to content you.
much obliged, Your Lordship, section 3, 4 and compels private hospital to discharge public duties without adequate financial safeguards, effectively
Okay, right.
maintaining their
Right. Then how you will substantiate with 19(1) subclass C? Sorry, subclass 6. What 19(1) subclass 6?
91 subclass G, my Lordship.
6, not G.
You can give extension.
We'll extend. Let it. Okay, so your researcher will assist. Okay, it's a reasonable restrictions, right?
Much obliged.
Then you jump with your European Court of Human Rights.
Much obliged.
Would you ready to substantiate the same where we the constitutional bench accept? Would it binding?
My
What is
Lordship,
a
we
value?
couldn't finding, my Lordship,
Okay.
but we are humbly make it as a reference to your before the Honorable
Okay,
Supreme
that
Court.
particular judgment is given to protect the interest of individual human rights. Whose human right is violated in this particular case?
My Lordship, human violation. It's not about human violation. We are stating the professional autonomy. Professional
Do the judgment of European Court of Human Rights speaks about professional autonomy? Please read.
No, my
read
Lordship,
it.
it talks about the penalty. Racial nexus to the gravity of the wrongdoing, my Lordship. We are stating that cancellation of license for not performing the
Counsel, do you think that such cancellation, which is a harsh measure, will be done without hearing you or without giving an opportunity to the hospital? There will be rules, there will be an inquiry, and they will be framing the rules also. So you are assuming that the government will do things without hearing you. You want to impose all the alternate pattern, right?
But what we were saying is we also known about the clarification of the Moot proportion. Paragraph 14 states that the section 7 of the DBRH Act, which provides for the cancellation of hospital license, is subject to the principle of national justice and due process.
Counsel, go to your footnote number 65, page number 33 of your written submission. It's for your petitioner, or sorry, appellant. 65, page number 33, footnote number 65. No, counsel, footnote number 65. 65, it's not, that's under 4.7.
Beg your
Ah,
World Health Organization Health System Regulation Guidelines 2018, my Lord. Yes, my Lord.
WHO recommends to regulate proportionality and collaboratively preserving private sector viability.
Yes, my Lord.
How it is contravening the WHO mandate?
Health system regulation should balance public interest with sustainability of private healthcare providers. Automatic license cancelling and civil or disciplinary licensing in DBRH Act 2025 contravene. It's literally contravening, my Lordship. Compelling a doctor to participate in organ.
It is only your, sorry, it is only your apprehension. It is not even a legitimate expectation in our opinion. See, in the absence of any provision that paves way for mandatory or immediate decision by the government, your argument does not hold good. You can go to any other point in which you want to challenge this particular issue number 4.
Apologize, Your Lordship. Apologize for the inconvenience of the bench, Lordship. Much obliged, Your Lordship. Much, Your Lord.
In the larger interest, whether professional autonomy or public health stands on a higher footing.
Much obliged, Your Lordship. We are known for the fact that large public interest should be a main priority for the government to consider. We are respecting that. But what we are stating is The civil and disciplinary.
Counsel, what we are submitting.
Much obliged, Your Lordship. Sorry for my language. Much obliged, Your Lordship. What we were submitting, humbly seek submission was the professional were literally struggling, my Lordship. Considering the section 5A, subclass A. Please consider section 5, which talks about the mandatory establishment of brain death certification internal committee in every hospital. Every hospital doesn't have that much huge corporate. We are medical associations. There is a charitable institution. There is a small, medium hospitals would be there. Imposing.
Counsel, you know generalia omnibus non derogant. Here we are speaking about only the hospital which has 100 beds. Why you are imagining something we have a micro, small, charitable, minimum, medium? All these are out of the context of the problem of the Takshinas. Why you are bringing everything? You substantially submit.
Much obliged, Your Lordship. What we were substantiating as such. May it please the Honorable Supreme Court of Astoria, in the light of submission made to adjudicate and declare that the compulsory reservation of 15% bed for the below poverty line patients and the emergency treatment obligation imposed on private hospital are contradictory to the Constitution of Astoria. The provision mandating facilitation of organ donation upon brain death without prior explicit consent violate the right to privacy, bodily autonomy and dignity. The restriction under Section 5 of the DPRH Act 2025 compelling the transfer of retrieved organ solely to the government agency is unsustainable in law. The imposition of civil and disciplinary liability, including a license cancelling for denial of emergency treatment, is unreasonable and disproportionate. In the spirit of justice, this Honorable Supreme Court is prayed to grant such other relief as it deemed to fit in the interests of the equity and good conscience, guided by the wisdom of Tirukural. Giving to each his due is man's highest gain, and for this act of justice, the appellant, as in due bound, shall ever pray. Much obliged, Your Lordship.
Thank you. Yes, please. Respondents, come. Please.
You are defending the state, no?
Yes.
So try to answer the questions, doubts put forth by them. Don't repeat whatever is written on your paper, right? You heard them, no? Okay, sorry.
Behalf of the respondent side, warm greeting, Your Lordship. Lordship, Council seeks permission to address this bench collectively as and Lordship. Much obliged, Your Lordship. Lordship, if the bench well aware about the fact, I would like to move on the jurisdiction, Your Lordship. Lordship, our co-counsel says that an opposite counsel said that they came into...
Counsel, the learned counsel for appellant. Don't say opposite counsel.
Much obliged, Your Lordship. Our learned counsel says that they came into jurisdiction under the jurisdiction of Article 133, Your Lordship. But the appellant jurisdiction of 133, it's needed, the civil matter, Lordship, is needing Article 134A, Lordship. It's need to certificate issued by the High Court, Your Lordship. Much obliged, Your Lordship. Now we are appearing behalf of the Dakshin Pradesh government, state government, Your Lordship. I am counsel number 1 dealing with issue number 1, Lordship. My co-counsel dealing with issue number 2, 3 and 4, Your Lordship. For the gracious work done by the researcher, Your Lordship. Counsel seeks permission to address the issue, Lordship. Much obliged, Your Lordship. Lordship, issue number 1. Whether the compulsory reservation 15% of beds and the imposing emergency treatment obligation to the private hospital, it's violating the Constitution of Australia, Your Lordship. The most humble submission made before the Supreme Court of Australia, thus not violating the Constitution fundamental rights and constitution provision, your lordship. It's upholding the article 21 of the constitution, your lordship, and it's creating under the reasonable restriction of constitution of Australia, your lordship, under the article 19 subclass 6, your lordship, and it also fulfilled that reasonable classification test under the article.
Council, in the absence of any clarity about the definition of those class of people who are coming under the below poverty line in terms of any fiscal ceiling or something, how are you going to justify the reasonable classification?
Much obliged, your lordship. Firstly, your lordship, the Australia had an 1.3 billion people above, your lordship. We are large population. It had a large population, your lordship. The most of the much obliged, your lordship. According to the Dakshin Pradesh Act, it's restricting and imputing some obligation to the private hospital, your lordship, based on the
Other judge's clarification is you reserved 15%. What is the rationale behind it?
Your lordship, this percentage fixation based on the actual need, lordship. I would like submit the document number 2, lordship. Union of India versus Moot Kairat Trustee, your lordship. This judgment establishment and committee, your lordship. This committee name is Justice Qureshi Committee, your lordship. This committee also suggested that with extending 10% with giving a free treatment in the matter imposed to the private hospital, lordship. It's not being allotted government land, your lordship. Based on the actual need, we are fixing the percentage, your lordship, not based on the approximately, your lordship. It was the actual need. That's why the fixing 50%, your lordship. It's a need and also
My question is very distinct. Are you going to adopt the same formula which is applicable to economically weaker section under Article 15(6), or do you have a separate formula for deciding who come under the definition of below poverty line? Come with a proposal or a law, you should define first the terms. Who are all coming under the definition called BPL? Or the criterion or
What is
criteria
the
for
economic criteria or criterion you are following it to fix who may be called as BBL, below poverty line?
your lordship, apologies, lordship, the council never. Much obliged, your lordship. Lordship, my first limb of my argument is it's upholding Article 21, your lordship. The 21, in the case of state of Punjab versus Mohinder Singh Chawla, this court, the Supreme Court upheld that, your lordship. The right to life is including a right to health, your lordship. Right to health is integral part of the right to life, your lordship. And also the report number 1, the document number 1, your lordship. Pashchim Bengal Gate Mazdoor Committee versus Union of West Bengal, state of West Bengal, your lordship. The Honorable Supreme Court stated that the constitution obligation to the state to provide adequate facility, medical facility, your lordship, and ensure no persons can deny emergency treatment the only grounds of incapacity of financial background, your lordship.
We bench is not at all doubting what is your intent. Your intent is to provide healthcare to all.
Yes, Lord.
But which made you to encircle only 100-bed hospitals?
Much obliged, your lordship.
If you want to pass the test of Article 14, there must be two different class of persons, and there should be a difference and on the basis of intelligible differentia.
Intelligible difference.
What is the rationale behind such a class of persons being divided into two?
Your lordship, the matter of the rational nexus with the object of the status, your lordship. Here, the classification between the hospital with more than 100 beds and similarly institutions in rational based on the capacity, facilities to public responsibility, your lordship. With a classification based on the beds, your lordship, beds capacity of the.
Is there any attempt from you, Dakshina State, 1,000 beds, 75%, 500 beds, 25%, 100 beds, 15%?
No, Lordship, only because of Lordship, we are setting standard, Your Lordship.
Setting should be for all. Which may give to answer to only 100 beds.
Your Lordship, it's an actually Lordship more than 100 beds or more than 100 beds, Your Lordship. Not in lower, less than 100 beds, Your Lordship.
How do you say the hospital having, as ma'am said, a hospital having 90 beds? How do you distinguish between the two is the question my sister judge wants to know. What is the differentiation between the two? That's not. Do you have any
Your
report?
Lordship,
Do you have any report of any committee?
Indian no, Lordship, but the classification does not requiring mathematical presumption based on, Your Lordship.
Intelligible differentia.
Your Lordship,
The specific contention made by the learned counsel for the appellant was there are hospitals which have 100, 15, 500. They are fully exempted.
Your Lordship, the differential must have
In pari material, there is an act called RTE Act, where 15% of the seats are reserved to poor student in private schools. It does not deal with the strength of the school or a class. 15% flat. You say 15% only in the hospital, which has more than 100 beds. My brother judge wants to know, also my sister and another brother, how do you fix the 15%? On which basis?
Any technical committee you have constituted in order to check?
Indian no, Lordship.
Okay, continue.
Your Lordship, the classification of 100 beds, Your Lordship, the document number 4 and 5, I will submit the mail, Your Lordship.
Counsel, you said you haven't conducted any study. Then you are bringing only the judgment. The judgments allow us to understand how the right to life and livelihood ensures on right to health care. Our concern is not why do make a law. Our concern is when you made a law, have you attempted to include the intelligible differentia? That's what, sir. All judgments they are giving. There are no fact finding.
You have no answer?
That's what.
Then go to the next question.
Respond, sir. Researchers, let them do something. Okay.
Okay. You go to next point then.
Lordship, actually, Lordship, the Parliament Standing Committee on Health, Your Lordship, 2022, Lordship.
Council, this particular law is made by the union or state of Dakshina, Dakshin Pradesh, right?
Yes, Lord.
Why you are bringing union?
Because,
Who has
Your
a,
Lordship, we are adopting.
no. Who has a constituent power to make this particular law? Is it by Dakshina state? Is it by union?
The state, Your Lordship.
State. Then what is the point in referring standing committee report?
Your Lordship, we adapting Central New Health Policy 2024, Your Lordship.
Okay,
It's mandate to
which paragraph of the central government policy says any hospital which runs with 100 beds can be reserved 15% off? You read?
it's not directly says that, Your Lordship.
Then how you will assume? Because we are playing with the legislative competence, how we will assume? Would constitution encourage us to?
Indian no, Lordship, the policy the adopted, Your Lordship. The policy was the adopted, Lordship. The policy mandate to all states, Your Lordship, including the Dakshin Pradesh state. It's located in the Australia country, Your Lordship. And also the policies to impose the.
Please read the objective of that NHR, National Health Policy of the Union Government.
The policy mandate to all state, Your Lordship.
Where you have mentioned which paragraph of your
Page number 27 of the Moot proposition, Lordship, 14 paragraph number.
No, we are asking from your written submission of memorial.
Once again.
Compromise is common for both you and the appellants. Where you have mentioned this particular attempt is in furtherance of the policy what Austria government made. Which line of your written submission says? Okay, please continue. Please assist her. Okay, continue.
Challenge put forth by the appellant petitioner is that the absence of upfront payment, the suffering financially is going to suffer by the hospital, is the main challenge by the petitioner and appellant. What do you say for that? They were more on this particular point. You want them to give treatment to those person without any upfront payment. That means at no cost. And there is no guarantee that you will reimburse the amount to them. You will only give incentive. That's what they said. What is your answer for that?
Your Lordship, Section 3, it's divided into two parts, Your Lordship. Section 3, subclass A, Lordship, it's deal with non-communicable deadly disease, Lordship. The government imposing certain obligation to the private hospital, Lordship, to giving free treatment, Lordship. But the government refunding the manner of the tax deduction or the equal fiscal, Your Lordship. In the matter of communicable disease, Lordship, the Section 3 subclass B, Lordship, it's restricting the waiving only the hospital requirement of payment, Your Lordship. Lordship, it's only the at the time of emergency they restrict to demanding payment, Your Lordship. Before that, the treatment done, the hospital can claim that payment, Your Lordship, to the persons, Your Lordship, who taken treatment, Your Lordship. The Act does not restrict that, Your Lordship. About the payment in Your Lordship.
Point is, such treatment will be very expensive, right? Non-communicable, emergency, so treatment will be very expensive. How do you expect a private player who runs the institution by investing a huge on infrastructure, equipments, and salary of doctors to give it without any upfront payment?
Your Lordship, it's very exception thing. Sorry, Lordship. It's very exorbitant cost, Your Lordship. We accept, Lordship. But the human life, it's more than exorbitant, Your Lordship. And also, Your Lordship, we intended to save the people, Your Lordship. That's why we're restricting the timely treatment, giving the main objective, giving the timely treatment only, Lordship. That's why we are restricting the prior payment, Your Lordship. We're not restricting the after the payment, Your Lordship. The hospital can demand it, Your Lordship. Lordship, only one issue I will handle, Your Lordship. Yes, Lordship.
Or on Article 19(1)(g), that is the freedom of commerce and trade of a private hospital. What is your answer for that?
Your Lordship, it's a fundamental rights, Lordship. We accept, but all fundamental rights not absolute, Lordship. It's add and reasonable restriction, Your Lordship. Your Lordship. It's in reasonable restriction under the Article 19 subclass 6, Your Lordship. Under the Article 19 subclass 6, empowered to the state to imposing reasonable restriction, Your Lordship, in the interest of public welfare, Your Lordship.
How many reasonable restrictions you have? Which reasonable restrictions you are taking for this particular case, counsel?
Your Lordship.
Under Article 19 subclass 6, how many reasonable restrictions you state can enjoy? Which restrictions you are using to controlling the hospital which has 100 beds?
Your Lordship, it's based on it's regulating based on that. Yes.
No answer, please. Don't waste your time. Go to next point. We will see whatever is being.
Only one issue.
Only one issue.
The rest, sister counsel will have.
Apologies, Your Lordship.
Okay. So leave it to the sister.
And also,
My brother Gazi has pointed out, there may be a reasonable restriction, but it must be fair. In the garb of or guise of a reasonable restriction, you cannot impose something which is unfair, right? We have got doctrine of manifest arbitrariness, right? We have got a lot of doctrine to test the constitution of a law. So please be very clear that whatever restriction you impose must be reasonable as well as fair.
Lordship, the reasonable restriction must be fair and just, Your Lordship. Now, there is no violation of arbitrary, Your Lordship. There is no arbitrary nature, Your Lordship. Hence, the balancing individual rights, the private hospital liberty, and also balancing the public interest, Your Lordship. It's a reasonable restriction, Your Lordship. It's a fair, Your Lordship. Thank you, Your Lordship. And also, Your Lordship, the Property Owner Association with the state of Madhya Pradesh, Maharashtra, Your Lordship, the Supreme Court reaffirmed that that state action redistributing private resource, Lordship, the private resource for public welfare, Your Lordship, with giving couple of fair, Your Lordship. We heard.
Point in bringing private property issue here. Are there any properties acquired?
It's in a resource material, Your Lordship.
What is your understanding on resource material?
Your Lordship, here we directing the private hospital to giving timely treatment and 100 more than 100 beds. We allocate the 15% of beds, Your Lordship. That's in resource material, Lordship.
Would you like to connect with the redistribution of material wealth between have and have nots?
Your Lordship, we direct that, Your Lordship. We directing
Where
the.
is the constitution based council?
Your Lordship.
The distribution of material wealth, where is the constitution based for state of Dakshina?
Your Lordship, that also comes under the reasonable restriction and classification, Your Lordship.
Please open 1906. Open our constitution and read. To supply constitution to our Lord council. 1906.
Not in subclass, the Lordship, of the side classes shall affect the operation of any existing law insofar as the impose and prevent the state from the making any law imposing a lordship in the interest of the general public, Your Lordship. Reasonable.
General public, one, then.
Reasonable restriction on the existing of the right conferred by the said subclass, Your Lordship, and existing law insofar as they related to or prevent the state from making any law relating to, Your Lordship. It's there, Your Lordship, the interest of people, Lordship. That's why we're restricting private hospital, Your Lordship.
See, only one question to you, last but not the least. It is a comparison between the privileged and the less privileged. Okay, according to you, you want to give free treatment for the less privileged at the cost of the hospital which are serving the privileged, right? Am I right? Or you have nothing to say? No idea. Leave it to your counterpart. Fine. No.
Sister council.
Publish, Your Lordship.
A warm greeting to the honorable bench present over here. If the bench permits, the council would like to address the issue number 2, 3 and 4, and our council would like to collectively address the as my lords and individually as your lordships and ladyships. My lords, the issue number 2 is that whether the provision inquiring the private hospital to felicitate the organs removed from the deceased persons with the consent of the family member and without the prior consent of the deceased persons, whether it is a violation of right to privacy, dignity and bodily autonomy. The humble submissions made before the Honorable Supreme Court is that here the removing of the organ from the deceased person with the consent of the family member, and when there is a prior consent or refusal given by the deceased person, here the deceased person right to privacy and dignity and bodily autonomy does not violate, my lords. For the benefit of the bench, counsel would like to divide the argument into 3 limbs, my lords. The first limb deals with the whether the deceased person has a legal status, and the second limb deals with the procedure established under the Dikshan Pradesh Right to Health Act of 2025, specifically section 5, my lords, and there is a no religious violation has been made, my lords. My lords, the first limb of my argument is that deceased person has a right to legal status and right to privacy, right to autonomy, bodily autonomy and the dignity, my lords. My lords, as per the Salmon's jurisprudence point of view, when the person dies, when the person dies, the rights will die, my lord. But the law recognizes the postman's dignity, respect with the burial, my lords. I would like to submit the document number 1 before the honorable bench, which clearly states that the National Human Protection Act of 1993, which states that every human must be respect with the dignity, even either he may be living or deceased, my lord. My lords, I would like to continue my the first limb of my argument with the specificing mention the section 3 class 42 of the General Class Act of 1897, my lords. My lords, this particular definition of the persons has been states that does not include the dead person, my lords, but the memorial page number of the respondent side council in the Jamuna Das Prasad versus State of Madhya Pradesh. The Madhya Pradesh High Court mentions that deceased persons also includes the definition of person, my lords. So that my humble submission.
You must be knowing about posthumous dignity.
Yes,
You just can't deny that. Article 21 contemplates dignity of dead also, right?
Yes.
And you just read Article 25, subclause 2. You have a Constitution of India with
Yes,
you?
my lords.
Please.
My lords, Article 25 class 2, nothing in this article shall be effect in the operation of any existing law or any prevent of the state from making any laws, my lord. My lords, I would like to
No,
answer
just please finish reading.
in this, my lords. My lord, on the explanation 1,
Regulating.
class 25 class 2 subclass A, regulating or restricting any economical, financial, political or other secular activities which may be associated with the religious practice, my lord.
Next.
And 2 class B, providing the social welfare reform or through open Hinduism religious institution or a public charter or classes and the sections of the Hindus, my lord.
What is your understanding of this provision?
My lords, here as per the article 25 class 2 says that any religious practice which has been following by particular by the person, it should not be violated, my lords.
So my question is, according to my knowledge, in Islamic, Arabic, Abrahamic religion, no person's dead body is to be mutilated unless the final rites is fully completed. How are you to question all these things in the name of state?
Yes, my lords. My lords, I would like to address this particular issue in my third limb of my argument. I request the bench to complete my first one and second limb, my lord.
No issues. Answer this.
Please answer and proceed.
My lords, as per the my third limb of my argument says that there is no religious violation has been done, my lord. First, I would like to submit the document number 4 before the honorable bench, my lord, which document number 4 clearly states that Sandan Kumar versus the collector, my lord, in the year of 1999, my lord, in the document number 4, which has been states that any particular law issue in the matters of Article 21. Article 21 right to life and the Article 25 right to religious must be read into together, my lords. I would like to submit the document number 5 of the before the honorable bench, Arjun Gopal versus Union of India by the Honorable Supreme Court delivered a judgment in 2017, my lords. This Honorable Supreme Court mentions that Article 25 is subject to the Article 21, subject to Article 21, my lords, which means right to life, my lords. If Article 25 can be overridden by the Article 21, when there is a threatening to the health or any particularly in the living persons, my lords. My lords, I would like to submit the document number 6. Particularly the Honorable Bombay High Court delivered a judgment in 2024, my lords, which clearly states that if a person need an organ, it is also right under the Article 21, my lords. My lords, by these 3 documents, I would like to submit before the honorable bench that even a right to life will be overridden by the religious regulations, my lord, and religious as a fundamental right. My lords, as the learned appellate state council mentions that it is a belief, my lord. Belief cannot be enforced under the Article 25, my lord. Here, the practice, my lord, as per the Article 25, the freedom and consent of free profession practice need to be ensured under the Article 25, my lord.
No, it is express. I mean, forget about the council.
It is, my lord.
The judge just mentions clearly that Abrahamic religions treat that before burial you shouldn't do any ritual.
It is, my lord.
So, in that case, how will you justify?
My lords, that even there is no explicit specification of the religious exception, my lords, because Section 5 clearly defines and structuring in the procedure by law, because as per the Section 5 class D mentions that a deceased person's organ can be removed, my lord, with the consent of the family member, my lord. If a family member can be refused, they can, if they have been following a religious belief, they can be refused by the family member, my lord. I would like to justify this particular submission.
Shall I put like this? According to you, Article 25 is subject to Article 21.
My lord, indeed as my lords. My lords, I would like to justify this submission in the document number 7, my lords, in the Mohammed versus Union of India. Mohammed versus Union of India in the year of 2022 judgment, my lords. My lords, this particular judgment giving the family person has the right to demand that the organ should not be taken from the deceased person, or even if the person is following any religious practice of the deceased person, the family member can demand that he can be buried, or he can be followed this particular religious methods. So if the submission.
Counsel, I think you would have also, when you were learned counsel for the applicant, appellant as submitted.
It is, my
There
lords.
is no definition for a family. So what is your inclusive definition for a family, counsel?
My lords, as per the family's definition has been not provided in this particular act. But as per the Marriage Act and the Hindu Family Act, the family can be defined and
We are in the secular country. Why you have to take it from a family, from a Hindu family?
My lords, as per the Austria.
For example, a person has got 2 wives. From you will get the consent.
My lords, indeed, my lords, this is a particular point, the question to be answered before the Honorable Court. In case of this ambiguity has been on logical question.
Till then, you keep the body very much safe in the mortuary.
It is, my lords. My lords, I would like to say that here the in case of the family member has been becomes questionable. Here the family member includes maybe a nominee or in charge in person. In charge in person includes an unclaimed body, my lords. If an unclaimed body has been found out by the government, in case of the unclaimed body, the person in charge has been mentioned in the.
No, counsel, don't bring anything unclaimed body, because our clarification is very clear. So it's out of our discussion. Please discuss
Yes,
with
my
the
lords.
chain.
My lords, in person in charge, it seems to be that, my lords. Here, in case of any deceased person, a person can be a nominee. But the person who with the billing of my lord, as per the, I would like to guide the honorable page to the
The main attack by the other side, why should the organs retrieved should be given only to the governmental authorities?
My lords, it is a big question before the honorable court, my lord, because as per the private hospital, my lord, the private hospital formed the private hospital management association, my lords. They are having formed association, they have signed the MOU, memorandum of understanding within their private hospitals, my lord. And mostly, particularly in the Dikshan Pradesh state, they have been 65% of the organ donation done by the private hospital only to their own patients. My lord, the most important question here being raised, my lord, the private hospital can be, the organ donation or organ transplantation can be done by the economically sound people, my lord. And most importantly, my lords, here, the Austria is a medical tourism country, and most importantly, most of the foreigners has been coming to the Austria.
You mean to say that government will retrieve the organs and distribute to the,
distributed to the necessity and the urgency,
including private hospital and government
Yes,
hospital?
my lords, as per the section 5 clearly states that I would like to guide the honorable bench to the page number 28 in the particularly section 5, my lords. First, section 5 class A, mandatory to establish the brain death certificate by the internal committee in every hospital headed by the senior most medical officer in the respective hospital, my lords. The section 5A is clearly mentioned that there must be a head by the senior most medical member, and the section 5 class D says, section 5 class B states that the brain death certification of the internal committee should be monitored by the state committee, my lords. And state committee by the Director General of the Health and Service and other members. Other members include, my lord, the expert members, my lords.
What is alarming to the other side and to us is section 7.
My lords, at the section 7, I particularly addressing the issue number 4.
Yes, counsel. Before going to section 7, is there any national law or policy in state of Austria?
particularly in the section
with
7, my
respect
lord.
to organ transplantation.
My lords, as per the organ transplantation, even Austria has been adopted the World Health Organization guidelines, my lord. I would like to submit.
Is it applicable to all state of Astoria? It's only for Dakshina.
My lords, it is applicable to all state of the Austria, my lord.
Okay.
As per
What is the difference of the law which is made by the Astoria and Dakshina with respect to organ transplantation?
it is, my lords. My lord, I would like to submit the before answering this question, I would like to submit the document number 2 before the honorable bench.
Yes.
My lords,
That is document 2.
document 2 before the honorable bench, which clearly says the guidelines of the World Health Organization in the year of 2010, my lords. If an organ has been removed, particularly in the deceased person or maybe a living person, the organ must be need to fulfill some condition, my lord. The first principle.
Which guiding principle?
In my lords, for principle number 1, my lords. Principle number 1, there must be consent of the person or maybe a family member. It must be express consent or maybe it may be oral consent, my lord.
Okay,
And
whether all these things are included in our Dakshina's Act?
yes, my lords.
Where?
My lords, as per the section 5 class D states. Yes, my lords. My lords, as per the section 5 class D, the report of the case brain death, the private hospital shall felicitate to retrieval of the organ with the consent of the family. My lords, this particular consent of the family has been interpreted in the clarification of the Moot court proposition questions, my lord. When there is an explicit consent of the deceased person or a refusal.
Which paragraph of your written explanation?
My lords. My lords, as per the clarification 12, my lords.
Read.
Clarification 12 states that the section 5 class D of the Glc Pradesh Act of Right to Health Act 2025, the organs shall be retrieved after the brain death, permitted only with the consent of the deceased person, where the deceased person not given a prior consent or refusal, my lords.
Okay, that's fantastic. Then where is the choice for the so-called nominee?
It is, my lords. My lords, I would like to submit the.
A nominee may be a person outside the family also.
Mentioning.
A nominee may be a person outside the family also.
It is, my lords. My lords, I would like to the which has been submitted the honorable judge, honorable Supreme Court judge.
What is the general principles of law between family members and nominee?
My lords, there is a classification of the family members and the nominee, my lords, which has been, I think, submitted the judgment, which clearly states that a close.
A nominee can represent the estate of the deceased. Can he represent the dead body?
There is a judgment.
My lords, in the judgment document number 7, my lords.
There is 7. Can you read now?
My lords, document number 7 states that the right of has been submitted before the bench.
Proceed,
My lords,
proceed.
document number 7 states that the right of next kin, the deceased person have their right to bury with their religions, with the which has been upheld by the close relation or the near relatives, my lord. My lords, here the near relative can be interpreted in this particular case as a nominee, my lords, because when there is an absence of the family member or the person in charge
Also, I think you can be easily saved to read the definition of family in any law which is applicable to Astoria.
A near relative can never be a next friend or a guardian or a nominee. Nominee can never be a near relative. Need not
It
be.
is, my lord. My
Need
lord,
not
as per
be.
in case of any procedure has been involved in the government, insurance policies and nominees can be the family members, my lord. As per the Insurance Act, they have been mentioning the, in case of any death insurance, the nominee has been mentioning, my lord. The nominee can be the family member, my lord. So it was been referenced.
Skip this point and move on.
Yes,
Move on.
My lord,
We are on more on point in section number 7.
it is, my lord. My lord, as per this issue 2, I would like to submit the final document before the honorable bench, document number 8, my lords. The UN Human Rights Committee, in the particularly the general comment of the 36 and 36/2018, my lord, I would like to.
Wait, what is the legal status of general comment here for this court?
My lords, here I would like to submit this particular report as a reference, my lord. Here,
No, I'm asking whether you are submitting as a reference or mandatory or whatever. What is the legal status of general comment in international law in the first
it
instance?
is, my lords.
In international law, what is the legal status of general comment?
It is, my lords. My lords, this general comment has been discussed in the UN General Assembly, my lords.
What is a general comment?
Council's brother J's clarification is noted comment at the definition of law to accept.
My lords, it does not comes under the law to does not comes under the ambiguity of law, ambit of law, my lords, because here it is a general command. We have been discussing particularly in the organ transplantation. We have been making a lots of
Okay,
convention.
it is not covered to the definition of law.
The law.
What is its legal sanctity?
It is, my lords. My lords, as per this general command, they have been discussing in the particularly UN General Assembly, which this particular
Council General Assembly may discuss thousand. Why you are presenting the same to the bench?
it is, my
What
lords.
is its legal sanctity?
My lords, as per this general command has been taken into the consideration by the.
Be very specific and clear.
It is, my lords.
Is it a part of any declaration or a treaty to which Australia is a signatory or not?
It is, my lords. This particular general command has been recognized by the Australia through the World Health Organization guidelines 2010 guidelines, my lord. It has been submitted before the honorable.
Are you the signatory to the declaration?
It is, my lords. My lords,
Whether it is authoritative or declaratory.
Declaratory.
it is authoritative, my lords. My lords, before it,
How do you say it is authority?
my lords, as per this particular provision,
What is the general command? Read the title.
my lords, I will
Read
not-
the title of the general command.
Comment.
My lords, the United Nations Human Rights Committee General Command number 36 for 2008.
Can it supersede the Constitution of Australia?
It is no, my lords.
Then
My lords,
Read the title of the committee report.
my lords, as per this particular committee report dealing with the
What is the title of the report?
report.
General Comment number 36 on
Part
Article 6
2018.
of the International Convention on Civil and Political Rights on the right to life.
ICCPR Article 6, my lords. This particular provision, Austria is not.
Can you say that such a declaration is binding on your country?
No, my lords. This particularly this.
You can only take a clue or it is only a persuasive. You are not, their question is very specific.
It is, my lords.
Try to answer them with specific terms.
It is, my lords. Apologies for it, my lord. My lords, I mean the council has been clarifying that this particular general command has been not been binding value and particularly Austria is not a signatory member. But
What? Are we not signatories to, Austria is not signatory to the ICCPR?
my lords, this particular provision is not ICCPR has been Austria as a signatory member, my lords. By having relying on the particular general command, my lord, it cannot be a binding value. That's why, my lord.
Try to convince the court with the local law and the constitution, not to go over international law which is not binding according to you.
Yes, Council, in the General Comment, which paragraph you are asking us to get an inference? Is it of 32 or 34?
My lords, has been underlined in the article 6, my lords, ICCPR.
No, no, whole comment itself,
It
article
is no, my lords. Our whole comment we have been pinpointly making
32 and 36.
pinpointly changed and underlined in the red lines, my lords.
That's what it's saying from paragraph 32.
It is, my lords. Right? My lords, this general command.
We not asking for.
It does not speak anything obligatory or directory. It's only a comment.
So you have violated two paragraph 32 and 34, you read both.
And
For the sake of bench.
my lords, this, can I go?
Please.
Yes.
The state parties need to take and among the other things and appropriate measures to establish the truth relating to the events leading the deprivation of life, including the rebelling on the reason and targeting the individuals and the procedure employed under by the state force before the during and after the time and the deprivation occurred and identifying the bodies of the individual who they lost their lives and it should be disclosed relevant to the investigation to their victims to the next case. My lord.
The United Nations takes stock of some exigencies prevalent in the world. How do you say it is binding on you?
My lords, apologies for my lords, it is not binding in nature. If the bench permits, if there is any objection related to the issue number 2, the council will clarify.
Skip that point and go to next
Yes,
point.
my lord, the issue number 3 specifically address that whether the organ deposited only to the government and government authorized agency, whether it has been sustainable under law. Sustainable under law. My lords, here the humble submission made before the Honorable Supreme Court that here the organ transferred from the private hospital to deposited only to the government and government authorized agency is has been sustainable under law, my lords. I would like to divide the argument into 3 limbs, my lords. First one deals with the statutory provisions, particularly mentioned in section 5 class 3, my lords.
Just a minute. There is a demand for a liver.
It is, my lords.
There is only one liver available for transplantation and donation. 2 patients are waiting in the queue. One in the GH, another in the private hospital. Whom do you prefer?
My lords,
Is there any guidelines in your...
Yes, my lords. I would like to submit the. My lords, is there a guidelines, my lord?
To be framed or you already framed?
It has been already framed, my lords.
Take to us.
Yes, my lords. annual report of the year of document number 3, my lords. My lord, as per the annual report has been mentioned before the submitted before the honorable
Annual report of
health and welfare, my lords. Particularly, this deals with the national organization tissue transplant, and this specifically deals with the state organ transplantation, my lords. My lords, this report specifically in the section 5 also mentioning that state organ transplantation registry has been maintained by the government, my lords, between the state government of the Glc Pradesh, my lord. My lord, in case of the demand in the one liver, there is a one liver demand in the both private and public hospital. As per the registry, who will be the first and necessary and the urgency of the particular patient, the liver will be given to the particular person. This,
Council, please read section 6 of
6.
the Dakshinas Act.
yes, my lords.
It is only the decision of the registry. Basis of medical urgency, and there is no question of any preference being indicated.
My lords, as per the state organ tissue transplantation registry shall allocate the donated organs basic medical
No, on the basis of.
on the basic medical urgency.
Slow, man. Don't be in a hurry.
So
On the basis of medical urgency and necessity under the guidelines of national regulatory.
framework.
That's what we want to ask you.
There is a national
Where is the framework?
for SOTTR.
Yes, my lords. My lords, as per the annual report submitted before the honorable bench 2024 to 2025, particularly substantial under the regulatory framework, my
When
lords.
this act was made, Dakshinas TPRH
In the year of 2025,
2025, when this report was,
2024 to
where is the report
2025.
after the enactment of this act?
My lords, but this report has been, this act particularly mainly implemented for the below poverty line peoples and the transplantation of organs, my lord. But this report specific, this organization like state,
Council, this is a section created by you, Dakshina state.
it is my lords.
You are council representing the Dakshina state,
It is my lords.
right?
Yes, my lords.
Where is the report to say you are providing organ based on SOTTR and the guidelines given by National Regulatory Framework?
It is, my lords. My lords, as per the section 5 or 6 states that state organ tissue transplantation registry and organization, my lords, which was existing before the enactment of the 2025 laws, my lords. The fact is silent about this particular registry or organization.
Okay, that registry made under what act? You have a registry. Registry is made under what act?
My lords, as per the
Compromise silent. Okay, then how you created this registry?
my lords, as per
Which authorizes you, Dakshina state, to make this registry?
my lords, as per the Transplantation of Human Organ Tissues Act of 1994.
Where is the power of the state government? Read that section. Power of the Dakshinas to frame a separate registry. Read.
My lords, separate legislation has been not mentioned, my lords. But
Council, you only presented here. There was a registry formed before the enactment of this act. So you should have a power to make a registry.
Yes,
You
my lord.
mentioned about the Organ Transplantation Act. Which section of Organ Transplantation Act allows you to form a registry?
it is, my lords. My lords, before the clarifying this particular section of this Thoughts Act,
Organ donation or harvesting comes under which entry and which list?
my lords, as per the entry 2, my lords, state list and the entry 56. I'm not
It's only state list only.
state list, my lords. My lords, I would like to submit the Transplantation of Human Organ Tissues Act of 1994, Section 13, my lords. Appropriate authority. The central government shall appoint the notification.
Then how do you say it's a state
My lords,
legislation?
in the section 13 class 2, my lords. The state government shall appoint by notification one or more appropriate officers can be purposed.
That is only nodal officer.
My lords, next section. My lords, this particular section 13 class 2, my lords, and also section 13 class A says that the advisory committee to advise the appropriate authority, my lords. Appropriate authority has been mentioned, need to guide under this particular
They cannot frame rules now, only guide.
my lords.
See, if it is under the concurrent list, we can write in now.
Section under the Transplantation Act emphasizing power of state government to make the rules.
Exactly.
My lords, the state government, as per the section 13 class C, the national organ tissues removal and storage, my lords. this national organ has been divided into three stages, my lord. National, region, and the state, my lord. This state has
What
not
the second one? National?
regional, my lord. Apologies, regional.
That's what you said.
You won't say religion. It gives a meaning. Okay.
My lords, national, regional, and the states, my lord. My lords, here I would like to state that even particularly, my lords, as per the we have been deviating this the Dikshan Pradesh right to health act and going towards the
That is the core issue. That is the core issue, not deviation.
My lords, as per the clarification, they have been mentioned that it should not.
Right, you should say you are deviating. You should not say we are
My
deviating.
lords, apologies for my lords, but as per the state organ issues registry, which must be and as per the council has been submitting that this act may be prevalent in my lords, because as per the issues transferred.
Yeah, better you move to section 7. Section 7 is it? Time is going to be over.
Clearly mentioned.
Only one more minute. Section 7 is a very important point which they attack very, very, very strongly.
Yes, my lords.
Okay, sir, how much minute we can
We
give?
can give 3 more minutes. 3 or 4 minutes.
We'll give five.
We can compensate.
We'll compensate.
Give the maximum 5 minutes.
That's okay, that's okay.
Then we can compensate, no issues.
No compensation, sir, because
My
already we
lords,
have
No, that's
argued.
rebuttal, sir, rebuttal.
So,
Rebuttal
2
adjustment.
minutes, 2 more minutes.
Rebuttal adjustment.
No, he has a full issue. Let him take at least.
You just answer the legality of section 7.
It is, my lords. My lords, as per the section 7 says that the obligation imposed on the private hospital, if they have been not fulfilled the obligation imposed on the Dikshan Pradesh right to health up to 2025, the license will be cancelled with the as per the natural justice, my lord. My lord, before I would like to submit that Dikshan Pradesh right to health act of 2025 is preamble, my lords. My lords, as per the clarification, they have been mentioned that these clarification number.
No, we are not on your competency to take action against the hearing officials. What is the mechanism or rules or framework, and what is the procedure we are going to follow? Because it will be a very harsh punishment if we cancel the license of the hospital.
My lords, I would like to answer this particular questions through the clarification, my lord. That act does not define any regulatory authority, my lords, particularly Moot court proportion. But they are in the clarification, point number 4 clearly states that the existing medical professional contact regulation will be followed, my lords. My lords, here existing medical profession contact regulations are the Indian Medical Council Act of 1956 and also the Clinical Establishment Act of 2010.
Where is the question of criminal liability?
My lords, that's a no criminal liability.
No, that's all. They made it as.
They have, is there only criminal
My
liability?
lords, as per the issue 4 has been raised before the honorable bench, whether the civil and disciplinary liability imposed on doctor
Okay.
and the second look that the cancelling of license towards the private hospital, my lords. My lords, here the civil and disciplinary liability has been invoked towards the doctor, my lord. As per the clarification mentions that
Whether the civil liability will be on the institution or the doctor's concern.
doctors and the and in case of denial of emergency treatment, the civil and disciplinary liability imposed on the doctor and the license will be cancelled.
Is it a vicarious liability on the part of the doctors?
My lords, as per it cannot be seen into correlated, my lords.
No, unless you make the individual doctor liable, you cannot vicariously make the institution liable.
My lords, it cannot be a vicariously liable, my lord, because due to, my lords, as per the section 4 specifically deals with these civil and disciplinary liabilities of the particular doctor, my lord. In case of the gross negligence done by the doctor or the denial of the emergency treatment, they will be under the portion of civil and disciplinary liability, my lord. Here the civil and disciplinary liability only for the gross negligence and the emergency denial of emergency treatment. It has been properly defined in the Moot court clarification point number 11. Gross negligence means the medical jurisprudence existing, my lords, and the emergency treatment in the point number 10, my lords, emergency. They have been willfully denial of the particular particularly denial for the emergency treatment, he will be a civil and disciplinary liability, my lord. My lords, and the here cancelling of the private hospital license, particularly when there is not for fulfilling the obligations under the Dikshan Pradesh Act of 2025, my lord. If the bench is satisfied with the issue
Go to prayer.
4, my lords,
Pray.
much obliged, my lords. The light of issue right, argument advanced, authority cited. We praise before the Honorable Supreme Court, we please you to dismiss this petition and ensure that the compulsory reservation of 15% for the below poverty line and the free treatment for the other than the non-communicable disease, it is constitutionally valid. And the deceased person's retrieve organ from the private hospital with the consent of the family member when there is a prior or explicit consent or refusal by the deceased person unless it does not violate the constitutional rights like right to privacy, dignity and body autonomy, and the organ retrieved by the private hospital deposited only to the government and government authorized agency. Government authorized agency has been includes private charitable trust, my lords. So it is not cannot be says that unconstitutional. It is sustainable under law, and the civil and disciplinary liability imposed on a doctor for the gross negligence and the emergency treatment is valid, and the cancelling of the private hospital license, particularly among the denial of emergency treatment is valid, and the court may pass any order or orders which may deem fit under this.
Don't say any order. Whatever order you want, you ask for it.
The court may dismiss this particular petition under the circumstance of the case in the interest of justice, equity and good consent. For the act of finance, the respondents and counsel is bound forever, my lords.
Thank you.
Thank you.
Good job.
It's pleasure ordering before the court, my lords.
So much time exceeded. Let them take 5 minutes. No, that's all. We'll
Maximum
give
5
5
minutes.
minutes to them. We'll give 2 minutes. 5
Maximum
minutes to the appellant. Then 2 minutes.
5 minutes each,
Then 5 minutes will become.
maximum. At the end of 5 minutes, ring the bell.
So since the learned respondent counsel exceeded 3 minutes, we are giving a 5 minutes to you. Then let them confine with 2 minutes. Okay, in a way balance.
The counsel seek permission to approach the
Come. Add பண்ணி plus minus பண்ணீங்கன்னா correct ஆகும். 3 minutes extra.
The council only on the points that were argued by them.
The council now, with the court intelligence, my lords, we have few contention over the friendly learned respondent council, that the state acknowledged that creating a monopoly for the organ that very inefficiency, bureaucracy and organ wastage due to logistical delay that the act purports to prevent, thereby violating the right to health of the recipient must be initiated by the respondent council. And the second contention is about, is it reasonably, how can a medical professional be expected to comply with the duty to provide emergency treatment when the act failed to defines the specific condition, time frame or clinical criteria? Specific medical condition should be provided that constitute an emergency risk, arbitrary and disappropriate penalties for the medical professionals, my lord. How the learned counsel questioned the locus standi position as it was already been admitted by the Supreme Court of Astoria, paragraph of 90, it undermines the court's admission, my lordship. Then the contention, the fourth contention is about the respondent counsel failure to accommodate the health beliefs betrayed the pluralistic ethos of the Astorian constitution, which safeguard the freedom of religion as a structural value integral to the social harmony. The appellate counsel raised humble question about the cold ischemic time for the organ is precious, forcing an organ to travel to center back to back instead of forcing directly to or making an arrangement directly to a matching recipient in a nearby private hospital is not going to contempt about. Then setting a standard 15% and bet no answer regarding to the reimbursement is grievance of our side, my lordship. My lordship, Section 13 of the Toda Act, as they mentioned by the learned co-counsel, the power is vested with the central government, as clearly from the provision itself, but the learned respondent counsel has misappropriated. The
Misappropriate.
Misunderstood.
Misinterpreted.
Understood or misinterpreted.
Okay. Listen.
In Moot's case cited by the learned respondent counsel, the state ordered for the 25 reservation by the land for the hospital for the purpose. They had a consideration, but there is no rational basis in that case. Much obliged, Your Lordship. The counsel for the appellant is much obliged to the Honorable Court for its patient and gracious hearing.
Good job. Thank you.
Much obliged, Your Lordship.
Which moments the council would write for?
Please. Only 2 minutes for you.
Yes, my lords. My lords, I would like to answer the learned appellate side council mentions that 7 more questions. First, I would like to answer the question number 1, whether the jurisdiction has been admissibility. My lords,
Not a jurisdiction, is mentioned about locus standi.
locus standi, my lords.
131 versus 134.
Yes, my lords. My lords, as per they have been mentioning the religious rights, my lords. It was clearly stated in the Honorable Court judgment. We have been proceeded that the Article 25 will be subject to the Article 21, my lords. My lords, and they have been mentioning that the forcing of the private hospital to take the organs of the deceased person, my lord. There is no forcing, my lords. As per the World Health Organization guidelines, Principle 2 and Principle 1 clearly states that the consent must be taken, and Principle 7, my lords, it is to be referenced before the Honorable
It's
Bench.
only a surrebuttal.
Yes, my lords. My lords, as per the may have been mentioning that the seventh principle, no profession or any other doctor should not be forced or under any undue influence, my lords. My lords, also they have been mentioning that the 15% of reservation, my lords. My lords, I have the a proper justification regarding the 15%, my lords. My lords, as per the Kerala Private Hospital Association versus Secretary Labour, in the year of 2004, the judgment has been delivered, my lord. This judgment particularly says that the hospital can be with the infrastructure, they can be measured whether it is a specialized hospital or non-specialized hospital through the allocation of beds, my lord. Because here the 15% the reservation here state confining why the 15% has been made as the socio-jurist versus Union of India. This case has been particularly mentions about the reservation of 25% and 10%, my lords. Here the 25% of the this particularly invoking of contract, my lord. But here why the state imposing this particularly 15% for the below poverty line, my lords. But the socio-jurist versus Union of India, it has been overall the free treatment to be provided for the Austrian peoples, my lord. My lords, I would like to submit the before the honorable bench, the learned respondents, the learned appellate side councils mentioned that we have been misinterpreting the Article 13 class 1 and 2, my lord. As per the Article 13 class 2, the state shall appoint by the notification one or more officer by appropriate authority for the purpose of the act, my lords. My lords, with the due permission, the respondent side councils praised that please dismiss this petition and uphold the order of the Diksha Pradesh High Court, my lords.
Dismiss the appeal. Okay, thank you.
It is, my lords.